Okay. Welcome, everyone. We're going to get started with the meeting of the Code of Evidence Oversight Committee. I'm the chair of the committee, Justice Raheem Mullins. Before we get started, I want to take the roll call. So if you hear your name, please just indicate that you're here. To make the meeting run smoothly, if you could mute your microphone when you're not talking, that would be great. The one other housekeeping matter is when we get to discussing the topic at hand today, if you could just introduce yourself with your name, since we are live streaming this, that will be helpful for the public to know who's speaking. I don't think you necessarily need to do it every time, but wouldn't prevent you from doing that when you're going to speak. Okay, so I'm going to now take the call. First is the Honorable Judge Karen Goodrow.
Yes, good afternoon. I'm here. Thank you.
Good afternoon. The Honorable Elliot Prescott.
Here.
The Honorable Judge Michael Sheldon. If you could just
Judge
unmute.
Sheldon is here. I can see him.
Yeah, if you could unmute Judge Sheldon. I'll come back to you, Judge. Attorney Robert Edelman.
Here.
Attorney Jennifer Bourne.
Here.
Attorney Tim Costello.
Here.
Attorney Darren Cunningham.
Here.
Attorney Mike Gaylor.
Here.
Attorney Jack Steigelfest.
Here.
And Reporter of Judicial Decisions Eric Levine.
Here.
And Academic Advisor Professor Julia Simon Carr.
I'm here. Thanks.
Judge Sheldon, you with us?
Yes.
There we go.
Good.
Thank you. Okay, no problem. So as I said, welcome to the meeting of the Code of Evidence Oversight Committee. I want to specifically welcome our two newest members, Attorney Jen Bourne and Attorney Cunningham. Attorney Bourne is filling the vacancy left by Attorney Bruckman, who I would like to now publicly thank for his service to Connecticut in general and to this committee specifically. I think he put in tireless hours to make this committee better and push forward this work. And he retired in between our meetings, so didn't have a chance to publicly thank him for his contributions. So thank you for stepping up to serve Attorney Bourne. And Attorney Cunningham is filling the vacancy technically left by Judge Massicott. She was our Attorney General's representative, and when she was nominated to Superior Court, that left the vacancy for an Attorney General, and Attorney Cunningham has stepped up to serve in that capacity, and so we thank you for also becoming a part of the committee. Now, before we get to the topic at hand, I do have to approve the minutes of our last meeting. Do I have a motion to approve? The minutes have been distributed, so hopefully you've all seen them. Do I have a motion to approve the minutes from our last meeting on July 21st, 2022?
So moved. Judge Prescott.
Thank you. Do we have a second?
Second, Judge Sheldon.
Any discussion or corrections? Seeing none, the minutes can be approved unanimously. Okay, moving on to the main topic of our agenda of new business. Distributed to you all was an amendment to the code, specifically to section 7-3 and the commentary attendant to 7-3. I would like to have a discussion on the amendment, just to give you some background. This does, as you know, track Supreme Court decisions, two decisions, but really the Gore decision that laid out the test and changed the rule or amended the rule, however you look at it. And this was an effort to bring the code in line with that Supreme Court decision. we thought it best to have something to actually look at and consider. I want to thank Judge Prescott and Attorney Petruzzelli for putting this together for the committee to consider. And so I would like to open it up for us to discuss this if there are any comments, concerns, suggestions.
Justice Mullins, it's Judge Goodrow. My only question is whether the word surveillance was intentionally left out of the new subparagraph 2, where it says identifying any person in video recordings. I think consistent with the Gore decision, it might be best to say identifying any person in surveillance video recordings, etc.
Sure, Judge Prescott.
A conscious choice was made to leave surveillance out of the language. While Gore, of course, dealt with surveillance video, it's not clear that the same principles would not be applicable to other types of footage. I don't think there's anything particularly unique about surveillance footage. You could have someone capture an incident on their cell phone, for example, and that would implicate the very same concerns that surveillance footage does generally. I believe that there are cases under the federal rules of evidence that have extended similar principles to video footage that's not technically labeled surveillance footage.
It's a fair point, Judge Goodrow, and we did discuss that before submitting this, whether it should be surveillance or video recordings. But you feel strongly, certainly. Go ahead and let us know.
Just my nature, Justice Mullins. I apologize for feeling strongly. I do feel strongly based upon my reading of Gore, but I'm certainly not going to trip us up if there's a consensus. I'm happy to indicate that I'm wrong on the issue. Thank you.
Probably wouldn't use the word wrong. Just different opinion. Any other thoughts on this proposal that we have in front of us?
Justice Mullins, if
Sure.
I may, Jack Steigelfest. I don't have any substantive disagreement with what's written here. The only question I had on reviewing it was that we're taking up 3 paragraphs of commentary on basically a single case, which seems like a lot for I'm not sure that's consistent with the way we deal with most issues or cases in the code and the commentary. So it's just a thought I had in reading it, that much of what's here could be dealt with simply a citation to the case. But what the sentence in the first paragraph, for example, where you talk about in this narrow context, the court and Gore agreed with we're justifying why the code is being changed. We don't need to justify in the commentary why the code is being changed. It's just being changed. So it just seemed that there was more here than we might need. Again, not disagreeing with the substance of what's here, just the amount of what's here.
Yes, Judge Sheldon. I think that the point Karen raises, I happen to agree with the committee's decision, or the proposer's decision, to have the rule be broader. And it seems to me that might be worth a sentence indicating that although the decision in Gore was made in a case involving surveillance footage, the principles apply generally to videotapes which are identified in the process by the process that was used in Gore, and thus a broader rule is appropriate. So that's sort of going the opposite direction in terms of the length observation, Jack, but I think that the point is well enough taken that we would not want somebody to read it more restrictively because of the surveillance language in Gore. And I would think that the broader interpretation is more appropriate.
Judge Sheldon, are you suggesting that as like a sentence in the commentary? Because the
Yes,
rule
I mean,
itself says.
Jack's comments, I think, are sensible about length generally, but it seems to me that since we're trying to dichotomize between the thing that animated the court in suggesting what it suggested in Gore and the rule that we have, which actually is a broader rule, to put a finger on that and identify it so people don't mistake, reading Gore in as a limitation, I think would be a useful thing. So yes, I guess I am suggesting a sentence. No, I don't have language for that sentence, but I do think it would be appropriate to take note of the very thing that Judge Prescott said in light of Judge Goodrow's remark.
Again, Jack Steigelfest, if I may, I don't disagree with what Judge Sheldon is saying, and I think that's here where it says in the second paragraph of the second sentence of the first paragraph, where it says the holding is not limited to surveillance video and applies to any video recording. I don't have any problem with that kind of statement that clarifies the intent of the rule. It was the sentence after that I was raising a question.
Attorney Steigelfast, was it just that sentence, or were you recommending more of a reduction, like that? I suppose
just to
that sentence down.
Again, there's nothing wrong with this, and I intend to vote for it if it's the sense of the committee that this is the way we should go. I'm just comparing this to other aspects of the code and commentary where this goes into much greater detail, I think, than many other areas where we comment on the rule. That sentence in the first paragraph that starts with "in this narrow context," I think is different, and I reacted a little differently to it only because it seems like we're trying to justify why we're changing the rule of evidence. And while it's appropriate for the Supreme Court to explain why it's changing the rule of evidence, I don't think we need to do that. In the commentary, the rules changed. We don't need to justify why we're doing it.
And the two hands, Judge Prescott and then Attorney Levine. I think you're still muted, Judge Prescott.
I wanted to join, despite having played a role in authoring this, with Jack's comment about potentially shortening it. And one of the reasons why is if the Supreme Court or the appellate court in subsequent cases were to tweak any of these particular factors or the specific instances or tools that you use to evaluate this question, that we then have to go back and again modify the commentary, even though we wouldn't be changing the substance of the rule. And so to avoid that, I think the more we have the rule reflect the substance of the prohibition or the evidentiary question, and the commentary give the bench and bar access to the cases that they can look at that are critical to examining this issue, that's probably better than something longer that we would have to change from time to time just to reflect any subsequent tweaking of the case law.
Attorney Levine.
Eric Levine, just from a historical perspective with respect to the commentary was set up initially with the 2000 Code of Evidence to be a brief, succinct discussion of any pertinent code provision. So this is probably inconsistent with what has been done in the past in terms of having a 3-paragraph exposition. So just from a historical perspective, I certainly wanted to convey that to the committee. Thanks,
Attorney Levine. Attorney Bourne, I think you're still muted as well.
Thank you. Sorry about that. I would just say, though, I hear what people are saying about the length of the commentary and it being unusual, but it's the commentary that really forms the rule here, which is maybe also a little bit unusual because I don't get from what's written in the text of the rule itself what the holding of Gore is. You don't see from what's written in there. I mean, just saying it's admissible if such testimony meets the standards for admissibility under section 7-1 isn't going to explain that the court rejected what federal courts do in terms of general familiarity and require more than that, or what the factors are. So, I mean, I guess I can appreciate what Judge Prescott is saying, that if things are tweaked, then you'd have to tweak the commentary. But if the commentary is going to be shortened, then I think the rule itself needs to be tweaked so it's clear what the court said in Gore, because I don't think it will be obvious. And on that note, in the commentary, I would note too, I thought it was a little confusing in the second underlined paragraph that starts with "in making this determination." This determination isn't defined, and in the Gore decision, the court is referring to whether the witness is more likely to correctly identify the defendant than is the jury. But in reading this commentary, I wasn't clear on, is that the determination where these factors are relevant to, or is it whether it's admissible under 7-1? Is it whether it's admissible at all? That just wasn't really clear to me from reading the commentary alone without reading it with Gore. Thank you.
Thank you, Attorney Bourne. I don't know if I see anyone else's hand. I guess that leaves us with what to do, what we think should be cut, if anything, if that's the consensus. And Attorney Bourne's point, I think, is explicated in a recent decision from the appellate court in State v. Sumler. I thought sort of clarified that exact point that you're making, and brought that out of Gore. I mean, it's in Gore, but I think that's the first time, if I'm correct, that Gore was applied. And if we're going to make an amendment to include that point, which I think is a fair point to include, certainly open it up to everyone else. Maybe we make that point, amend this to make that point and decide what cuts we're going to make, if that's the consensus that some may need to be cut. You make a fair point, Attorney Bourne, but maybe there are things that we could cut. And I think it's page 150 of the Gore decision where the court sort of says more explicitly, in talking about non-precipient lay opinion testimony, that a defendant in surveillance video or photographs is admissible only if there is some basis for concluding that the witness is more likely to correctly identify the defendant from the photograph or video than is the jury. And then the court gets into explaining how you evaluate that totality of the circumstances. So maybe at the end of that paragraph, including that sentence. Does everybody see where I am? That might make it flow into, in making this determination, you're considering the totality of the circumstances. I don't know, Attorney Steigelfest, though. I may have deleted one sentence just to add another one. So I don't know how we'd be doing on length necessarily.
Your Honor, it's not so much length per se. It's just a question of whether in the commentary we want to go into all of these factors and lay out all of this tests which are found in the cases, or whether we simply want to refer to the cases for the tests that apply to the rule. I'm not. This isn't a hill I'm willing to die on. It's just a question of how you approach the concept of a code and the commentary, and how much detail you want to go into in the commentary. And whether that's consistent with how we've approached the project in the past.
Mm-hmm.
So from my perspective, I would shrink all of that down considerably. But again, I appreciate there are other approaches to doing.
Well, it seemed like there was some appetite to to shorten it. I think Attorney Bourne makes a fair point. There may be something we need to do with the text of the rule if we eliminate all of the commentary or truncate it too much. It might be helpful to at least see what truncating it looks like. And then if we agree that, you know, that there's enough in the commentary, we might make everyone happy. Judge Prescott.
This is a question for Lori, maybe for Julia if she knows offhand, but the related federal rule, it doesn't contain the specific factors that the court uses in making this determination in the rule, I assume. Do you know, Lori, offhand, or?
I can look it up if you give me 1 second.
Okay.
Yes, it does not have any factors. It just says, if witness is not testifying as an expert, testimony in the form of an opinion is limited to one that's rationally based on the witness's perception, helpful to clearly understand the witness's testimony or determining a fact and issue, and not based on scientific, technical, or other specialized knowledge.
And as I understand it, that rule has been interpreted to allow this type of opinion testimony with respect to the identity of someone on a video if it generally meets some of the same criteria that we have articulated in Gore.
That's my understanding as well.
Would you, to carry that further, would you be suggesting that maybe we don't need, I guess, the second full paragraph, even getting into and making this determination?
Yeah, I guess what I was saying was I would leave the text of the proposed rule as we have it and shorten the commentary as much as possible. I think it's difficult to do it on the fly.
Yeah.
I think, I'd be happy to take a shot at it. And particularly if Jack, if he wants to work with me on that, I'm happy to see what we can come up with. Again, trying to also accommodate, those who think, boy, it's helpful for the judge who's applying the rule to have on the bench, a quick place to go to look at the relevant factors.
I will just point out, if in other parts of the code we have included lists of factors in the commentary, or the commentary includes it, like 7-2 testimony by experts has a discussion of factors that have to be considered. So just because this all comes from one case, I don't know if it wouldn't be the only place where factors were eliminated in the commentary.
And I think in other places we don't do it. I mean, I think it's a little bit happenstance. We don't have a long explanation of all the things the court should look at in determining whether or not something was an excited utterance. You really have to go to the cases to do that.
Judge Goodrow, did you have something?
Just briefly, and I recognize I'm going in the opposite direction, but is there any usefulness to referencing the rule on authentication, I'm thinking because in the commentary it references voices that are identified from some electronic form. It may not be necessary, but.
Is that a hand still up, Judge Prescott, or that's from before? You're muted, Judge Prescott.
I meant to put my hand down, but I can certainly respond. I guess I'm not sure I understand what Judge Goodrow, what you're suggesting or where. This really isn't an authentication rule.
I guess that's the issue I'm raising, is whether with regard to a witness identifying somebody, maybe the 4 factors apply. I just thought that for consistency's sake, we might want to reference the authentication rule. But if you don't see it as an issue, what was the comment? It's not a hill that I would fall upon or trip upon. No, I'm sure I'm messing up that cliche. Okay, I hope I'm not missing anyone else's hand, and certainly interrupt me if I am. But Attorney Steigelfast, I don't ask people to work with Judge Prescott lightly, but if you would work with Judge Prescott and maybe put something together, I would be envisioning us meeting probably sooner rather than later, because once we iron out the recommendation we're going to make to the Supreme Court, I could get this on the Supreme Court's conference and approved fairly quickly, given that this is really tracking a Supreme Court decision. So in terms of public comment, I'm not sure there's the same need because it's effective already. We're just making the code line up to the Supreme Court's decision. So would you be willing to work with Judge Prescott to put something together and see if we could get something we could submit to the court?
Of course, I'd be honored.
Great. And thank you. I know it's a heavy lift, but I appreciate it. From there, I would still move on to the next part of the agenda. We won't have a vote on this today. We'll get a more complete version after Judge Prescott and Attorney Steigelfast work it up, and hopefully we can get that to everyone before the meeting and then be able to vote on it at our next meeting. But I did want Attorney Levine to give us an update on publishing a new book, actual booklet. There's several other options we could have. I may just chime in at the end, Attorney Levine, but can you give us an update on where we are with the code right now?
Sure, Justice Mullins. Eric Levine. We are pretty much all set with the book, which incorporates everything done since 2018, which was our last book. We have one final galley check to do, but that can be done in a day. One of the questions that I raised is, do we want to include what we're doing with respect to 7.3 in the 2023 edition? So sort of a way to appease the bench and the bar is to get a PDF of the current 2023 version that exists now without going to print. That way it will be available as a PDF online. And then once we're able to get through this 7.3 and get it to the court for approval, we can then add that on and then have a final 2023 version that would then result in a pamphlet or a paper physical copy that we would be able to get to all subscribers and everything. So that was a question. The alternative is we can just go with a booklet now, and that would probably take about 4 weeks to produce, even though we can get the PDF up within the next week. In which case then the changes to 7.3 then would end up in a book that would probably be published in 2024, beginning of 2024.
If I understand you, Attorney Levine. This is, so one of the things that I was thinking about is we could get a booklet with these 7.3 changes in a 2023 edition. And the difference would be whether a matter of maybe a month or two. Does that sound right?
That's correct. We could move pretty quickly once these changes were approved. If in fact we even need approval, I'm not sure of the time frame, but we can move pretty quickly. It usually takes legal publications about 4 weeks to get a print copy done because all the binding is done in-house. And we can obviously get a PDF up pretty quickly as well. So if this process with 7.3 is going to take a month to 2 months, that's pretty much your lag time with respect to a book if you wanted to wait till this 7.3 was done. If not, then we can go forward with the book. And as I said, we probably would wait then until the beginning of next year to print another book that would incorporate the changes to 7.3.
To me, it seems inefficient to do it that way. I think we're close enough, and hopefully we can get 7.3 wrapped up fairly quickly. And if we can do that, I think we can get a 2023 booklet out probably by early April. And that way we don't need to print one and then print another. That's my preference, unless I hear differently from anyone on this committee. I'll try to do what I can once we get 7.3 taken care of to get it in front of the Supreme Court and voted on. And then we can just have a 2023 booklet with all of the changes up to and including 7-3.
Would you like to go ahead, though, with the PDF of all the changes up to this point that would be available on the website? Okay.
Yes, and unless there's an objection from anyone on the committee, I don't see why we can't put the PDF up, book to follow as soon as we get this done. Because even if we printed a book right now, 7.3 wouldn't be in there until the Supreme Court approved it. So to me, there's no sense in printing the book yet. If it's only going to be a matter of a couple weeks before we can get 7.3 in it and just print the book with 7.3.
Is Judge Sheldon?
Yes.
Can you hear me?
Yes.
I certainly agree with that. And if I could, though, I would like to ask a question. If I can go back to the substance of the rule that we were talking about before the committee goes out.
Sure.
The tenor of the rule as it's written seems to be on the question of making a positive identification of an individual in the course of committing an offense, even though the rule talks about any act that might be relevant to the commission of the offense. And what I'm wondering is, what happens if, for example, someone presents a third-party defense and wants to present off of a surveillance video of the same site on 2 or 3 different dates, say, the picture of a third party who's claimed to have done the crime? The same rules apply because it goes to the ultimate issue of whether the defendant is the person in the video on the theory that the same person in the video is alleged to be the one who did the crime. Would the same rules apply to identifying from a video or a photograph someone else who may have been the person by virtue of his presence in that photograph who did the crime? Or does it only apply to the individual charged because we're dealing with the ultimate issue in an affirmative sense, the one who's identified as having done the crime? Is that making any sense to anybody? I mean, to me, it's a concern that if it's one rule that applies to the idea of being able to make an identity or a non-identity, a refusal to say that's not the guy, based on my experience with him, my knowledge of him, it seems to me that that rule ought to apply to any identity of a person in a video or a photograph that goes to the issue of the ultimate issue in the case, whether it identifies the defendant as the guy who did it or doesn't identify the defendant as the guy who did it. Seems to me the same logic applies to the idea under either circumstance. And I just don't want to have the rule read in such a way that it could not be so understood unless that is the intent. I realize that wasn't the issue in Gore, but it seems to me the logic of it would be the same. And so I'm really wondering whether or not it would be appropriate to ask the subcommittee to generify the rule to express its application potentially more broadly even than it's written now. I realize that's a feint to the left for all of you. I'm sorry about raising it this time, but I think that's a real concern.
Before we break up, can I ask you, Judge Sheldon, what do you think causes that limitation, or what do you think in the rule?
Yeah, because there's the comment about how it has to be an event that is, it's the ultimate, frankly, it's because it's the ultimate issue in the case. And everything is worded in terms of identifying the defendant. And it seems to me if you're identifying someone else as a third party who is the one who is involved instead of the defendant, then it's the same exact issue. And there should be the same limitations on the character of an individual's familiarity with that person, ability to identify the person, etc. Some of the criteria wouldn't necessarily be the same. For example, whether the individual has had his identity changed, or is wearing a wig or dark glasses or whatever it is. But it seems to me the same rule should apply if the ultimate issue that is gone to by the identification of a person in a photograph is who is the person who did the crime, because that is the ultimate issue to which all of this goes.
I was going to say, it seems like the commentary starts off by talking about individuals or persons in general, and then when we get to the factors, in paragraph 2, it starts to discuss defendant's appearance,
right,
and stuff like that. So maybe that would be a thing that we would need to, if we were going to keep the factors in the commentary, that would be something where we would want to make changes to that.
Yeah, I mean, the reason why we're talking about this at all, I think, is because the Supreme Court wrote what it wrote in Gore. And so in part, this is really a question of what the Supreme Court intended. But it seems to me the logic of the rule, on the same thought that it doesn't just apply to surveillance videos, should apply otherwise. And, you know, I can imagine defendants trying to introduce evidence like this. And I would think, frankly, that the state would want to limit their ability to do that to people who have the same capacity to make the identification as someone might to identify the defendant.
Judge, Attorney Edelman, did you have something?
It just seems to me that that's an excellent point, but that would have to wait for a court decision.
Well, except for the fact, if I may, that we're going beyond a court decision even by the text of the rule as being proposed here. And it's the court's own power to do that, which is part of what this committee is putting before them to act upon, something which is generally based upon a decision, but in fact goes further to deal with a reality that we now accept as appropriate to address. So I'm not concerned about that myself.
Judge Prescott, and then Judge Goodrow.
See, I'm not sure that I'm convinced that 7-3 is even implicated by the scenario that Judge Sheldon has presented. I would need to think about that a lot more, and I would be curious as to whether there's any case law on it, either in the federal system or elsewhere. But the third-party culpability evidence does not seem to me to bear directly upon the ultimate issue in the case, at least in the way that Judge Sheldon is articulating it. The ultimate issue in the case is whether the defendant did it. The possibility that someone else did it seems to me very similar to a lot of other types of evidence that would cast reasonable doubt on the identity of the defendant as the perpetrator. I'm just not sure if I got that evidentiary question in a trial where I would necessarily agree that it even implicates 7-3.
Can I give you another example, Elliot? And maybe it makes it clearer. Let's imagine that somebody's got video photographs of a birthday party, and it's the classic alibi. I wasn't there, I was at a birthday party. And so the defendant wants to introduce the evidence of the videotape and someone to identify him as the person on the videotape. It doesn't go to the question of whether he did it directly, because it's not identifying him at the scene or doing an act. However, in the defense, as it's raised, it goes directly to it. It appears by video evidence. And it seems to me that you're liable to have someone say, oh yeah, that's the guy right there. He is in the background. And in fact, I remember the shirt he was wearing. It's that strange green shirt. We even talk about clothing here in this identification thing.
Even in the pre-Gore cases, we've talked about the existence of other videos of the defendant that are not from the actual scene of the crime, the commission of the crime, as not implicating Rule -7-3. Now, I know Gore kind of changed all of that, said we're not going to make those distinctions, but I'm just still not sure it's a 7-3 issue.
Okay, well, I'm raising it because I think it's of interest, and if others don't agree, well, you know.
Judge Goodrow, did
Speak
you
your
want
piece.
to add something?
I just go back to my original concern, and I note that the language that we've used in the new subsection 2 states a lay witness may give an opinion that embraces an ultimate issue identifying any person in video recordings. And I appreciate footnote 2 in the Gore decision, which basically says that, you know, they use the term surveillance video and surveillance footage, but their reasoning applies with equal force, and I'm quoting from footnote 2, to identifications of a defendant in other types of video recordings. So although I agree with the commentary by Judge Sheldon, I'm back to wanting the rule to reflect what's in Gore. And at page 148 of Gore, they state, for all these reasons, we now hold that opinion testimony that relates to the identification of persons depicted in surveillance video or photographs is not inadmissible solely because it embraces an ultimate issue. So although footnote 2 expands it, I don't feel like that actually is the holding from the case. But I'm not on the appellate or Supreme Court, so I defer to those among us who are.
Well, I mean, I would just echo what Judge Sheldon said a few minutes ago, that part of the mission of this this oversight committee is not simply just to codify pronouncements of the Supreme Court, but to recommend changes to the rules of evidence that seem wise and appropriate. So I take a little bit broader view about what we're doing here, and don't feel like we're just simply trying to codify what they said.
Right. So, and if it's, you know, the way the process is set up, this is going to be a recommendation to the Supreme Court. So the Supreme Court is going to review the recommendation and accept it. So I think that's exactly right. There's a part that may be codifying, but there's a part that's advisory, was what this committee is doing. So I think with that said, maybe the committee can consider Judge Sheldon's point and see if there's anything that it needs to be done, should be done, or could be done with this section in light of his concerns.
I would appreciate
Okay.
it.
So I'll be in touch with Judge Prescott and Judge Steigel and Attorney Steigelfast, and we'll see maybe a time frame for when we could have something, and I could set up a meeting, hopefully in fairly short order. We'll meet again, with that being the topic of discussion. Moving on to item 4, I don't have any other business, but I do want to open it up to anyone else if there's anything you want to bring to the committee or think the committee should consider.
Just as a point of personal privilege, as they say over in the legislature, I just think we should congratulate Professor Simon Kerr, as she's just been named the Evangeline Starr Professor of Law at the law school.
Oh, nice. Congratulations.
Congratulations.
Thank you very much. I appreciate it.
I'm sure it was all your work on this committee that propelled you over the top. But that's great. That's great news. Okay, thank you. Thanks, Judge Prescott, for pointing that out. If there's nothing else, do I have a motion to adjourn this meeting of the Code of Evidence Oversight Committee?
Sure.
Do I have a second? You guys want to stay?
I'll second.
Didn't know you were having that much fun. Okay. If there's no discussion, I will adjourn this meeting of the Code of Evidence Oversight Committee.
Thank you.
Thank you,
Bye,
everyone.
everybody.
Thank you, Your Honor.